Thank you very much, Dr. Koenig. I think we really have to work hard now to basically add to these two very good speeches. And what I liked about your speech is you were talking about blind spots. I think that's what regulation in the end is all about. Find the blind spots, and once you found them, the work really starts, because you mentioned something else, which is then in the execution very important. Eliminate them as appropriate to the respective circumstances for the institution, the employee, and the consumer. The devil is always in the detail, as we know from regulation. Also, thank you for reminding not only banks, but also consumers and the buyers of financial products that not only the institutions themselves, but also the consumers, the buyers in the end, shouldn't rely solely on rating agencies' marks. In the end, also, EMIR and Dodd-Frank, we will talk a little bit about in the panel. Yes, they eliminate or greatly reduce settlement risk. Now, what are we doing with the collateral question that is coming up? Hotly debated, and therefore you're in sync with Luke Frieden. In protecting institutions, we have two dimensions: the static dimension, which is capital, but also, again, the human and dynamic dimension, probably much more important, risk management. And whether we have a recovery and resolution regime, or whether we have segregation again from investment and commercial banks, in the end, ultimately, if both don't work or are deficient, failure must be possible. I would like to invite all of you, also Emmerich, Müller, and Maijoor, now to continue via the panel discussion. Now, ladies and gentlemen, we start again with the yes or no questions, though not all the questions will go to all the participants. But if somebody here on the panel changes their minds, you may add, though you're not on my respective notice board. So the first question goes to Dr. Koenig and Mr. Müller. Simply please answer yes or no. Do you think that the new European system of financial supervision and the single supervisory mechanism will improve the quality of banking supervision?
Clear yes.
Clear yes.
Okay. Second question goes to all panelists. Is the degree of complexity of the European system of financial supervision too high?
I don't think so.
No, not too high.
Yes, I do think so.
I expected that.
Would otherwise get boring.
Ja, genau.
Third question goes to Maijoor and Emmerich Müller. Are you concerned about the increasing future systemic role of central counterparties?
Yes.
Yes, as well.
Fourth question to Dr. Koenig and Emmerich Müller. Do you observe a strengthened position of the CRO in banks in the years after the financial crisis?
Yes, clearly.
Yes.
And last question to all panelists. Is it useful if rating agencies become personally liable for their published ratings?
Basically, I think so. Yes.
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 It will be difficult to get a discussion.
Yeah. Well, right. Let's see. The devil is always in the details, so maybe when we come to the different questions, they're not solely related to the yes or no questions. The picture gets more differentiated. Dr. Koenig, talking about the European system of financial supervision, what will be the main advantages of the single supervisory mechanism? You have elaborated a little bit in your speech on this already. Maybe something to add with respect to the main advantages?
Well, I would again strengthen the harmonized supervision, or to adhere to using supervisory standards on a harmonized basis is the one advantage. That's a flip side, will hopefully reduce national bias within the system and therefore create more confidence, which only will work if we make sure that we are also learning from each other. And that means that the single supervisory mechanism needs to work together with the national supervisory authorities, because they will know about all the national nuances and all that. So it will have to be an integrated system. And to be fair, it is a giant task to set this up within 1 year's time.
We have already talked about the time frame, March 2014. Now there are three constituents in this. We have the ECB, we have the national regulators, and we have EBA, the standard setter. Why will the EBA still be necessary after having established the single supervisory mechanism?
Well, the first thing is the single supervisory mechanism, as Minister Frieden pointed out, as I've also said, is unfortunately Eurozone only. The EBA is covering the entire European Union. EBA will be the master of the single rule book also in future and will to that extent be kind of the guardian of the European law. They will have the mediation powers when they believe that we are not adhering to this. The supervisory handbook, and there it gets a bit difficult, will be a joint effort of EBA, ECB and the national supervisors. And to be fair, we all need to make sure that this doesn't compete with what is now the work of the ECB to build up their supervisory manual for the Eurozone banks. So I think it will be all our task to make sure that EBA, with the, on the one hand, being the master of the single rule book, and on the other hand, working on a supervisory handbook, has a role to integrate, call it the Eurozone, with the rest of the European Union.
Now, there is clearly a role for both EBA and the ECB. Stephen Maijoor, in banking supervision going forward, then we will have two important players, the ECB and the EBA for the single rule book and technical standards. Could this also be a role model for security markets?
Well, I think the solution that we now have for the banking supervision and banking regulation, I think it's the right response given the situation in the banking side. But going to the securities markets area, I would like to emphasize 2 points. First of all, it is extremely important that we keep the view and the perspective of the 27 and of the internal market of the 27. And although I fully understand the choices that have been made now in the area of the single supervisory mechanism, we have to be very careful of importing this debate on Eurozone, non-Eurozone into, for example, securities markets area or insurance area, because it will make it much more difficult to keep this perspective of the internal market. And so I would also be in favor of really focusing the single supervisory mechanism only on banking supervision. And if in the future there would be any tension to say, let's put insurance companies in there, or CCPs in there, or trading venues in there, it will be more and more difficult to keep the internal market of 27. So that would be my argument. It's the right response for the banking supervision, but it's not the model that we should copy for other parts of the financial markets. And related to that, I think it's very important to keep both supervision and standard setting close to each other, and therefore having the current situation where at my table there are the supervisors that also use their experience and their expertise and experience to design the technical standards, I think is the right model. Now let's look at European system of financial supervision and developments from a different perspective, from the perspective of an institution, not one of the bulge brackets, but a very well-known traditional institution, Bankhaus Metzler. Emmerich, Müller, can you please describe the main consequences of the increasing complexity of the regulation for a private bank like Bankhaus Metzler, and does it already affect the business model?
Well, the main consequences are, I would say, 2 or 3-fold. Firstly, it drives costs. Complexity just costs money. And that leads, secondly, to the question which one always has to answer: is it really worth still continuing certain business activities? So you really have to ask yourself, is it worth doing it? if you drive smaller banks then out of business, the question is whether we really as a society want that, because it leads on the other hand to a certain concentration of business to larger banks. And we have experienced so far that just the size of banks might be considered as a problem as well. So one consequence might be in the long run that large banks are getting even larger. The third consequence that I see as a positive consequence and the aspect, when you are dealing with the question whether it's worth to continue a certain business, that might bring you positively to a more solid business model. And I mean, you can see it from a positive side as well. It forces you in just shaping your business, sharpening your business model, your strategy, and there are plenty of business opportunities still around there. So you can see that positive as well.
So you end up quite on an optimistic note.
For us, of course, yes. In general, it's definitely not easy, yeah.
Tackling the too big to fail problem, Dr. Koenig, in Europe and in the US, the obligations to provide recovery and resolution plans already exist. What will be the preconditions for their practical success, and are further steps or fine-tunings necessary?
I think it's still too early to say whether you need further fine-tuning of our framework for recovery resolution plans. But let me perhaps elaborate a bit. What do we expect to get in out of this? First of all, recovery plans are, for me, an indispensable part of risk management. In my former position, I would have called it, you always should have a plan B. That's probably the most basic recovery plan you have. Now, for me, but to take it a bit more serious, when we come with the word living wills, I'm always saying that goes a bit into the wrong direction. For me, the recovery plan is intended to make a company recover and not die. And to that extent, I think the basic part of the recovery plan is really to make sure that a company elaborates how, out of their own means, they can really deal with a crisis situation, and they should address it. It needs to be addressed early. It needs to be organizational, strategic measures, what have you. For me, therefore, one question to be asked is really, is a bank able to address a basic crisis out of its own means? Is a bank potentially too complex to address a crisis? Which, and I'm not getting tired of saying, is again a question for the bank's management and their board to look into, as well as it is a question for us to look into. So I think recovery plans, I don't have a doubt that you need to have them. Resolution plans is what we will put on top of this, because that's then up to the resolution authority to consider. And what I think what makes a lot of sense is the idea that the German legislator had. It puts a lot of probably burden on us to say, if looking into recovery plans, if considering resolution plans, a supervisory authority comes to the conclusion that an organization is just too complex to be unwound, then to give that authority the right to request changes to the organization. To be fair, this will be a burden that hopefully will never have to exercise that right, but to have it as a discipline, as a tool in our toolbox is probably helpful to convince managements to take action if need be. So I'm perfectly convinced that recovery resolution plans are a good tool. We will have to learn over time whether we really address the right topics there. But we are actually considering at least to also apply this tool to the insurance sector and not just to the banking sector. So if banks want to complain, you're not the only ones.
there is a second dimension of the too big to fail problem, and that is central counterparties, because a big debate regarding central counterparties is whether they or their major clearing members will in the end be too big to fail because of all the deal flow that goes via them. Emmerich, Müller, are you concerned about the future role of central counterparties, either with respect to systemic risk or that they may force you to reshape your business model?
No, I wouldn't say with regard to our business model, we can live with that. At the first glance, we welcome that idea of a central counterpart because it should reduce risk since we have all that collateral which is required there. What I really wonder, what might be the effect in the long run? In the long run, we might have a kind of collateral arbitrage there or whatsoever, and we might foster new institutions because there might be that there are only 3 or 4 counterparts left over, and that we might create a new too big to fail problem. And that's difficult to foresee, but we have to wait probably for a few years till we see the outcome.
So the practical verdict is still out?
Yeah.
Steve Maijoor, I understand from the pre-discussions that you consider these risks to remain low or at least be quite manageable.
Well, I answered yes on the first question on are we concerned about the systemic risks involved in CCPs, and obviously also considering the previous panel discussion asking for intrusive regulators, I don't think you would feel comfortable if I would say that I wouldn't be concerned. But I think at the same time we need to have this bigger picture is where we were starting from. And we were starting from a situation where derivatives trading was much more untransparent and where it were bilaterals and we didn't know where the risks were, and then suddenly there appears to be a large organization like AIG which is at the end of many obligations which it cannot meet. And so the fact that we're moving to a situation where many and probably most of the transactions will have a central counterparty in between monitoring whether the parties can meet their obligations will make the system as such much safer. And so let's first assess that and see that as a big plus that we're moving to central clearing. At the same time, we know that once we are in that situation is that you need to carefully supervise, regulate and manage these organizations. At the same time, they have a fundamentally different business model than a bank. They are much less susceptible to bank runs or to runs. If you're looking at the track records for CCPs in terms of failures, they are fundamentally different from bank failures. There's clearly much less. But again, it should be my role as a regulator to be concerned, to supervise it in an effective way. At the same time, I think it's a much better situation than a situation where all these transactions would be dispersed, where there would be no transparency.
But maybe to add, and the ECB may be a role model here, collateral management will be key.
Of course, if you're looking to the standards that we have published and that have been accepted in the past months, they are all about collateral, about margin requirements, about risk management techniques, about transparency, and it's a very elaborate and detailed system. And I think what is the good news is that it's also it's a level playing field across Europe. There is the same standard applies across Europe, and I think in that sense it's an enormous progress compared to the past.
Let's come to subtopic number 3, the role of the CEO. CRO. Sorry, yes, CRO.
Otherwise, I would have to reconsider.
CEO should always be also the CRO to a certain degree, but we concentrate on the CRO. Thanks very much for that. So first question goes to you. So. Dr. König, what do you think the most important amendments put in place by the regulator regarding the position of the CEO in the last years? What were the most important amendments?
Well, I think the most important amendment we did was actually the requirement for large banks that the CRO should be a member of the management board. That was not in our regulation. I think we always applied it to be one of the key positions within the company, but that's probably the major change we are seeing. And to have them as a single head and not two heads on one.
And apart from the changes which have been forced by regulation, do you also observe a general change in the role of the CRO in banks that are supervised by BaFin in practical terms? That's with respect to the seniority and the muscle the CRO has. Is there a general change also in attitude and in practical behavior?
I wouldn't see that as a change due to the change in regulation. I think over the years to come, the importance of the Chief Risk Officer function was actually seen. What we are to some extent seeing now is where in the past you had probably a CRO who was at the same time potentially the CFO, that is shifting in being two positions. But I think it is just a trend into putting more importance to the Chief Risk Officer function.
Emmerich, Müller, has the role of the CRO at Bankhaus Metzler changed in the last years, or would you say your business model has been a business model for decades and there was no major change?
Well, actually, that's just what I wanted to say. We have made it up for more than 330 years without even knowing that there might be an expression or institution called later on CRO, because we somehow felt that, at least our predecessors somehow felt that you have just to conduct your business in a reasonable way, and you, prior to entering risk, you think about just a simple question whether you can survive them when they realize. We hadn't had that institution. We now have it. We have our CRO as a partner now and in the managing board. We are quite happy with him. Otherwise, we wouldn't have him appointed. But definitely, the role has changed due to the regulation. I mean, we have those formal requirements as well, and it's good that someone takes more emphasis in the day-to-day work on all those tasks.
Could I perhaps step in? Could I step in there?
Yes.
Because I think what Emmerich was saying is important. I think in good practice, these are not changes due to regulation, just due to a complexer world. And to be fair, if you've just got a nameplate saying this is our CRO, you haven't achieved anything. It is a management board that has responsibility as a whole team, but there needs to be someone to have the head of being responsible for the risk management.
With respect to developing and expanding the business model, you say now you have this position and you also fill this position out. Does the CRO in developing the business model have a special role, like a guardian of the capital he or she should have in listed banks or in a private bank where the family has its own interest for a generation and most of its capital tied in the operation? Would you say they're really the owners are the chief risk officers and you don't need this disciplining function?
Well, actually, that's what I think. That we are a very special case. We are family-owned, and we partner consider us themselves as in a kind of a trust position, as a fiduciary position, to bring the bank from one generation to the other. And therefore, we have a certain strategy, a business strategy, and a risk strategy. So we wouldn't need that CRO function as such, because we all feel that we are in that position daily.
Entrepreneurial risk disciplines by itself.
Yeah.
True.
Apart from the fact that we are personally liable, I mean,
Yes,
if
yes.
there is someone running around blowing up the bank, they would blow us up personally.
Maybe that's
Makes things easy.
an interesting point for a separate discussion, whether, you know, some activities should be run again in partnerships, but we're not going to cover this topic here. Next point, Stephen Maijoor, and the last subtopic for today's panel discussion, rating agencies. Stephen Maijoor, why do you strive for personal liability of rating agencies for their published ratings?
Well, I should first say it's not my personal kind of striving. It's been a decision by Parliament and Council to give give liability to credit rating agencies. And I think we should first realize is that what you would like to have a situation is that a CRA, but like any other financial institution in itself, should have the right incentives to produce the right service. And we shouldn't rely on, let's say, the availability of supervisors to make the system work. And of course, we do our work, but in the end, a supervisor is kind of, and the action of a supervisor is an exceptional situation. So we should have the right incentives for CRAs to make sure that the ratings are correct. And in that sense, I think it's completely reasonable, like many other service providers, is that you're liable for the product and the services that you provide. Of course, it should be reasonable, as has been said earlier by Elke Koenig. It's very important that users of ratings and investors take their responsibility. But if it's clear that a rating agency didn't deliver on the basis of reasonable conduct of business or reasonable requirements regarding the methodology, and as a result of that, investors took the wrong decision, I think it's completely fair and reasonable is that then you're trying and can go back to that rating agency. So that holds in many areas of business, and I think it should also be relevant for credit rating agencies.
Elke Koenig, for understandable reasons, also BaFin supports the personal liability of rating agencies. On the other hand, isn't this at the same time an instrument to unintentionally support exactly those market participants who rely solely on external ratings by basically increasing or upgrading the quality of the big rating agencies?
I think that's a fair question, but I disagree with your conclusion. I think, as first of all, and I full-heartedly agree with what Stephen had said on personal liability for rating agencies. But to be fair, if someone would then refer to the personal liability as his only line of defense, well, you have to prove that it's intentionally misconducting and it was gross negligence and all that. So I think that's never a good idea to go. On the other hand, the regulation is not just about the personal liability of rating agencies. The other parts of the regulation will help us to reduce the mechanistic reliance on ratings and really foster again that market participant, competent authorities, all of us have to do our own judgment. It will reduce the reliance on ratings to a large extent through more focus on internal assessment. And I think that, for me, is even the more important part of the regulation. Personal liability is just a logical consequence, as Stephen said. If you are producing something that a lot of people consider a high-quality product, be it or not, well, then you should have personal liability for what you're producing.
Emmerich, Müller, your business is focused on the investment side, not so much on the credit side. With respect to both aspects, perhaps the investment side is even more important than the credit side. Do external ratings play an important role in your business model and in your services, or do you anyway focus predominantly or exclusively on internal assessments?
I mean, when it comes to our decisions or to decision-making, regardless whether it's for clients or for ourselves, it's quite clear we are the ones who take the decision. So there's no question about that. And we never would base a decision just on an external rating. I mean, that's absolutely impossible. Yeah.
So it's just one factor to look at?
It might give a first indication, it might give them ideas where to look, but it's our responsibility at the end.
Is there an internal rating process, or do you say you have other systems to basically rate or grade papers?
No, we have internal ratings for that.
And so basically the external rating surface, a kind of checks and balances?
Well, checks and balances, and of course coming from the client side and the instructions we get by clients, they have some external rating ideas, and within the investment guidelines, they once in a while have precise ideas what external ratings should be watched and what ratings not. So we have to deal with those ratings.
So internal assessment is most important, but you cannot really live without.
Yeah, we have to consider that they are there in the world and they have a market impact. Yeah, and since that's a fact, I'm also in favor for the liability.
Steve Maijoor, from personal liability, let's come to another topic which has been hotly debated in banking, but also on the political scene. Would the setup of a rating agency based in Europe improve the reliability of external ratings, and should or could it be sponsored by the EU?
Well, maybe on both points, I don't think we should have a model where the government or a governmental agency starts or funds a rating agency, because there would be various problems. The first problem would be this governmental rating agency would be competing with private sector organizations, and so you would get a kind of distortion in this market. And basically, if you would go to that model, you would say, let's stop the whole privately based rating agencies, because it's difficult to see from a competition standpoint how you could in the same market have governmental sponsored rating agencies and private sector based rating agencies. In addition, I think one important problem of a governmental funded or subsidized rating agency is that it would be very difficult to be a credible rating agency for governmental debt, because there will always be this element and this smell of not being completely independent. And I think that is the most important characteristic of a rating agency, is that it's independent. And so that part would be very difficult. I should say, is that currently, and going into the private sector model, which is currently all CRAs which are currently registered with ESMA, and we currently have 20, even the so-called American ones are required by the regulation to have a major representation and activity here in Europe. And so although we call them American rating agencies, in reality their analysts, their operations need to be here in Europe. And so to some extent we already have many European rating agencies, even the ones that are related to the Americans. And in addition to that, there are many real European rating agencies completely established here in Germany. And so in that sense, it's a bit of a kind of a twisted question. We already have some European rating agencies.
Okay, and you think this requirement and fact that substantial part of the operations is based in Europe is enough of a level playing field? Because there's often the criticism that the US-based agencies are a little bit home biased. So the level playing field would not be better if there was also a strong rating agency based in Europe and maybe one in Asia?
Well, you know, it's difficult as a regulator to defend the large rating agencies, but I think there's not much evidence so far is that they've been particularly easy on American government and relaxed on easy on American government and more restrictive and tough on the European ones, and they are subject to a regulatory system where we're closely watching what they're doing. We're looking at the way they implement their methodologies. We don't rate the ratings. That is their judgment because we don't want to interfere with their ratings. But at this stage, I don't think I would be particularly concerned about whether they are kind of tougher or easier on, let's say, European clients versus American clients.
Emmerich, Müller, considering there was a European rating agencies, there have also been business models discussed. Who is going to pay? Because always so far the issuers pay. And one, maybe not only for a European rating agency, but also for other rating agencies, one debate has been about whether the users of ratings should pay for those ratings and no longer the issuers. Would this be a role model, and would you consider to mandate and work with and pay European rating agencies or one of the other rating agencies?
Well, I'm just digesting what I heard before because I never had that perspective that those American rating agencies are the European ones. First thing I have to think about that. Nevertheless, this is one of those examples where markets are definitely wrong, and it's definitely wrong that the rating agencies are paid by the issuers. And that is there is just in nature there's a conflict in that, and I have no idea how that could be changed, and I don't foresee that for the foreseeable future that business model will change.
So you would
Well, the problem with whatever solution you will have, there's going to be conflicts of interest in this area, because even if you would be an investor and you would be investing in a product, you have a certain interest in that rating. So it is an area where I think it's completely right to have governmental regulation and supervision, because it's unavoidable that there's conflicts of interest. And if you would have a model where it would be based on shareholders, investors, then also in that situation you would have a conflict of interest. Maybe on the American, I know the names look very American, but you should realize probably is that the ratings of many of the products that you're used are conducted by an analyst sitting somewhere in Germany, speaking German and being born in Germany.
So quality always comes first and then location.
Quality is very and I
quality
think
of the analyst, not location of the rating agency.
But like every supervisor, to ensure quality in Europe, you need to have presence here. You need to be supervising activity here, and I think that is the point I wanted to make, is that within the current framework, even the American so-called American rating agencies have a very sizable presence here, and it's a requirement because otherwise we cannot supervise these activities properly.
Good. Thank you very much. Ladies and gentlemen, I would like to give you the answers of a field survey we have taken for this day. We have asked 3 questions, or here are 3 samples. The first, and you may recall them from our start. Do you think that the single supervisory mechanism will improve the quality of banking supervision? Roughly 35 participants, over 60% said yes. Roughly a quarter said no, and 15% gave no answer. So in general, the message seems to be we are heading in the right direction. Second, is the degree of complexity of the European financial system too high? Nearly 3/4 said yes. Roughly 10% said no, and again 15% no answer. So we seem to be heading in the right direction, but we seem to make the system down the road much less complex and easier to work with. And I think this is not only about the material aspects, but also about the technical implementation, which all of us too often and too easily forget. And the last, we have not touched this issue, but here the question comes: would a separation of investment and commercial banks be a useful step to reduce systemic risk? Now, this may be biased because the questionnaire went to bankers, right? But it's not so easy. Roughly 60% said no. Again, roughly 20% no answer. And 20% of participants from the financial industry said yes. So an issue to be hotly debated, but like Elke König has pointed out, too big to fail can be addressed in many venues. Separation of investment and commercial banks is one. The recovery and resolution system is another. And maybe we, in the end, avoid what we currently have in the energy markets. Too much parallel systems, in the end, kill the market. Thank you very much, Elke König, Steven Maijoor, Emmerich Müller, for joining us on this panel discussion. This was the last panel, and now, as I understand, the host, the Bundesbank, and here Andreas Dombret will give the final speech and close, therefore, the conference. Thank you very much.
Yep.